Hello and welcome to the 2TG Employment's monthly webinar for June 2022. This is the fifth webinar in our series where we provide an update on the key developments in employment law over the past month. My name is Conor Ewing, and today I'm going to be discussing two cases from the month of May on the very different subjects of hair loss and COVID. The first is a case which has attracted significant attention in the mainstream media, and that is the case of Finn and the British Bung Manufacturing Company Limited and King. In this case, the Employment Tribunal found that calling someone bald amounted to harassment related to the protected characteristic of sex pursuant to section 26(1) of the Equality Act 2010. Now, it would not be a 2TG Employment Monthly webinar without some discussion of the employment law implications of the COVID-19 pandemic. And true to form, the second case I'm going to look at is the EAT's decision in Rodgers and Leeds Laser Cutting Limited, which concerned whether the claimant's dismissal for refusing to return to work because of concerns relating to the COVID-19 pandemic amounted to automatic unfair dismissal under section 101D of the Employment Rights Act 1996. Turning firstly then to the case of Finn, the background facts to this case are relatively straightforward. Mr. King was employed by the first respondent as an electrician. The second respondent, Mr. King, was Mr. Finn's supervisor. In July 2019, Mr. Finn became involved in an altercation with Mr. King, during which Mr. King used a number of derogatory adjectives, including the adjective bald. He also threatened physical violence towards Mr. Finn. Perhaps less importantly for present purposes, there was then a further altercation between Mr. Finn and Mr. King in March 2021. And at a subsequent investigatory meeting, Mr. Finn produced a witness statement on West Yorkshire Police headed notepaper, which gave the false appearance that the police had become involved in the matter and Mr. Finn was dismissed. Mr. Finn brought a number of claims against his employer, including under the Employment Rights Act 1996 for unfair dismissal. However, today I'm going to focus on Mr. Finn's additional claim, which was somewhat of an add-on, that being called bald and other expletives amounted to harassment related to the protected characteristic of sex under section 26(1) of the Equality Act. It is helpful at this stage to remind ourselves of the test for harassment under section 26(1). This provides: 1, a person A harasses another B if A engages in unwanted conduct related to a relevant protected characteristic, and B, the conduct has the purpose or effect of 1, violating B's dignity, or 2, creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. Therefore, for Mr. Finn to succeed under section 26(1), he had to prove 3 things. Firstly, that the conduct was unwanted. And in this context, this means the same as unwelcome or uninvited. For present purposes, it's also important to note that one-off incidents can constitute harassment. Second, that the conduct has the purpose or effect of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And third, that the unwanted conduct relates to a relevant protected characteristic. And importantly, for reasons we will go on to look at in determining this issue, a tribunal should analyse the precise words used, together with the context, in order to establish whether there is any negative association between the two. And one of the more well-known authorities for that proposition is the case of Grant and HM Land Registry. Turning now to the tribunal's decision, the first question the tribunal considered was whether Mr. King's conduct towards Mr. Finn was unwanted. And rather unsurprisingly, they concluded that it was. They concluded that it was particularly because Mr. King referred to Mr. Finn in a pejorative manner, and the remarks were personal to Mr. Finn about his appearance. The second question the tribunal considered were whether the words had the purpose or effect of violating Mr. Finn's dignity or creating an intimidating environment. And again, the tribunal considered that the words were spoken with that purpose. They found that by Mr. King's own admission, his intention was to threaten the claimant and to insult him, and therefore the words were consequently said with the purpose of violating Mr. Finn's dignity and creating an intimidating, hostile environment. So far, so good. But of course, it is the third stage of the tribunal's reasoning, namely whether the word bald related to the protected characteristic of sex, which has unsurprisingly caused a bit of a stir. The tribunal reasoned as follows. Firstly, that while some women also suffer from baldness, as Chris Rock can no doubt attest to, it is much more prevalent in men and therefore is inherently related to sex. Second, in rejecting the respondent's argument that baldness could not relate to sex because women also suffered from baldness, the tribunal referred to the case of In Situ Cleaning Co Limited and Heads, where the EAC held that a woman had been sexually discriminated against under old legislation when a manager made a comment about the size of her breasts. The tribunal in Finn noted that the fact that men suffered from gynecomastia did not prevent the EAT in situ concluding that the claimant had been discriminated against on the basis of her sex. And they therefore reasoned by analogy that the fact that some women suffered from baldness does not mean that it was not a characteristic which could be related to men. And thirdly, the tribunal concluded that a purposive approach should be taken to construing the Equality Act. And they said that since the purpose of the Act was to reduce harassment in the workplace, and since men were more likely to be on the receiving end of an insult relating to baldness, it related to the claimant's sex. Of course, this decision is somewhat unusual in that it has been attacked in the media from both the left on the grounds that it has played down or delegitimized women's legitimate experiences of harassment in the workplace, and from the right on the ground that it is another example of political correctness gone mad. The first point to note, as will be well known to most of you listening, is that such an analysis often misses the distinction drawn in section 26 between harassment related to a protected characteristic, which in this case just happened to be the claimant's sex, and sexual harassment, i.e. unwanted sexual conduct under section 26, subsection 2. These are different things. Second, in terms of the tribunal's reasoning itself, one can somewhat understand how, based on a strict reading of section 26, the tribunal reached the conclusion that it did. But that is not to say there are difficulties with its analysis. First, I think it's fair to say the tribunal's analysis on the question of whether the conduct related to the protected characteristic is somewhat limited. They did not consider in any real detail, one, the context in which the words were spoken, i.e. a heated argument between two workers on a factory floor, and two, the purpose or the intention of the words spoken, as cases like Grant suggest tribunals should do when undertaking such an analysis. And it may be that the tribunal would have reached a different conclusion had they paid more regard to these considerations. Second, the logical extension of the tribunal's reasoning is that because baldness is more prevalent in older men, it could therefore be said that Mr. King's comments also discriminated against Mr. Finn or related to another protected characteristic, namely Mr. Finn's age. However, the tribunal simply rejected this argument as out of hand, but it's difficult to see any principled reason for this or why they drew a distinction between the protected characteristic of sex and the protected characteristic of age. Thirdly, I think the reason people feel uneasy with this decision is that, on the one hand, it's hard to disagree that the words used by Mr. King towards Mr. Finn were offensive and derogatory. But on the other hand, intuitively speaking, the insult does not really feel like sex-based harassment. And in fact, one might query whether the real unwanted conduct is the use of the various expletives that followed the insult balls. What this decision perhaps exposes is the fact that there is no freestanding claim currently for workplace bullying or harassment under the Equality Act, absent link to a protected characteristic. And unless claimants can bring their claim under the common law or another statutory provision under a separate regime, they could be left without a remedy unless the claim is construed somewhat artificially as falling under section 26(1). Finally, what does the decision mean in practical terms? Well, for claimants, the decision highlights that tribunals, when faced with a deserving claimant, will find inventive ways to bring claims within section 26 if they have to do so. That said, given it's a first instance decision on the facts, one might query whether it will have any real value as a precedent going forward. For employers, on the other hand, it serves as a useful reminder, if one was ever needed, that any offensive remarks made in the workplace, regardless of whether at the time the comments may be construed as just banter, run the risk of giving rise to an employment tribunal claim further down the line. And indeed, it is a useful reminder for employers that they ought to have in place clear and robust policies on workplace bullying and harassment to reduce the risk of this happening. Turning now to the second case, which I'm going to discuss today, which is the case of Rodgers and Leeds Laser Cutting. As some of our more loyal listeners will be aware, the first instance decision in this case was discussed by Emma Walker as part of our March update, and I would recommend listening to her webinar, not only for a detailed analysis of the first instance decision, but also of the impact of COVID-19 on employment law more generally. Today, I'm going to be focusing on the EAT's decision, which was handed down earlier this month. Again, the facts of this case are relatively straightforward. Mr. Rodgers was a laser operator. Due to the nature of his work, he was unable to work from home. At the start of lockdown, he stopped going into work because he had a vulnerable child and was concerned about the risk of catching COVID and passing it on to her. It's important to note in this case that the respondent's workplace was large. It was a warehouse-type space, about half the size of a football pitch, with only about 5 people working there at one particular time. They also had various measures in place, including social distancing, and had undertaken an external risk assessment. Mr. Rodgers initially obtained a self-isolation notice for a 6-day period from NHS 111, but did not go into work for the next 3 weeks or contact his employer whatsoever. He was accordingly dismissed. Mr. Rodgers brought a claim for automatic unfair dismissal under section 101D of the Employment Rights Act 1996. Section 101D provides an employee who is dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that in circumstances of danger which the employee reasonably believed to be serious and imminent and which he could not reasonably have been expected to avert, he left or proposed to leave, or while the danger persisted, refused to return to his place of work or any dangerous part of his place of work. As Emma highlighted in her webinar in March, At first instance, Employment Judge Anderson found that the claimant's dismissal was not automatically unfair. The thrust of Employment Judge Anderson's reasoning was that the claimant's decision to stay off work entirely was not directly linked to his working conditions. Rather, his concerns about the virus were general ones, which were not directly attributable to the workplace. Accordingly, Employment Judge Anderson found that the claimant's belief that his workplace presented a serious and imminent danger was not reasonable. And it was this latter part of Employment Judge Anderson's reasoning which was the focus of the appeal. Turning now to the EAT's decision itself, the EAT dismissed the appeal. There are three particular aspects of the decision which I wish to highlight. Firstly, His Honour Judge Taylor began his analysis by stating that there were effectively 6 component parts to section 101D, and this is likely to provide a useful starting point for any cases involving this subsection going forward. The first stage is to look at whether there are circumstances of danger. Second, it is to look at whether the employee believed that the circumstances of danger were serious and imminent. Third, that the employee's belief that the circumstances of danger were serious and imminent was reasonable. Fourth, the employee could not reasonably have been expected to avert the serious and imminent circumstances of danger. Fifth, the employee left, proposed to leave while the danger persisted, or refused to return to his place of work. And finally, this was the reason or principal reason for the dismissal of the employee. The second part of the decision I wish to highlight is that it also involved an interesting analysis of what was required under the first stage of the test, namely whether there existed circumstances of danger. The discussion centred around the question of whether it was sufficient that the employee had a reasonable belief that there were circumstances of danger, or whether it was necessary for there to be circumstances of danger objectively looked at as a matter of fact. And the reason this issue or difficulty arises is because in a natural reading of section 101D, it's clear that the suggestion is that this question ought to be looked at objectively. His Honour Judge Taylor considered this question by way of an interesting analogy concerning green gas. He said, for the sake of argument, assume that a green gas starts escaping at a place of work. Unbeknown to the employees, the gas is inert and entirely harmless. The employees leave, reasonably believing that there are circumstances of danger that are serious and imminent. They are dismissed for doing so, even though it is accepted that they acted reasonably by leaving the premises because at the time it seemed likely that the gas was dangerous and the risk of injury appeared to be serious and imminent. In such circumstances, should the employees fall outside of the protection of section 101D ERA because, objectively speaking, although not appreciated by the employees at the time they left the workplace, there was no circumstance of danger because the gas was harmless? That would be surprising. Somewhat typically, His Honour Judge Taylor concluded that it was not necessary for him to decide this issue because it was obvious that the COVID-19 pandemic gave rise to circumstances of danger, whether or not one looked at this question objectively or subjectively. However, it's clear from the foregoing passage that His Honour Judge Taylor thought that the answer ought to be that one looks at this question subjectively, and indeed it would be odd if employers were protected for reasonably but erroneously believing the seriousness and imminence of a threat to their health and safety as per stages 2 and 3 of the 6-stage analysis, but not for a reasonable but erroneous belief in the underlying circumstances of the danger as per stage 1 of the analysis. The third important point to highlight going forward is that His Honour Judge Taylor made expressly clear that it was not necessary that the circumstances of danger be generated by the workplace itself for a claimant to successfully rely on section 101D. And he cited the case of Harvest Press and McCaffrey in support of this proposition. However, on the facts of this case, His Honour Judge Taylor held that the tribunal was entitled to conclude that although the claimant had genuine concerns about coronavirus, he did not have a genuine belief that there were serious and imminent circumstances of danger which prevented him from returning to work. And there were a number of findings of fact made by the ET which justified this conclusion. First, the workplace was large and few people worked in it. Second, the claimant remained at work from the date of the announcement of the lockdown on 24th March 2020 until he left at his normal time on the 27th of March 2020. Third, the claimant could generally maintain social distancing at work. Fourth, the claimant was not required to go out on deliveries. Fifth, the claimant had not asked for a mask. Sixth, masks were available. Seventh, he drove to hospital when he was meant to be self-isolating. And eighth, he worked in a pub during lockdown. Therefore, going forward, whilst on the facts of this case the appeal failed, it is clear that it is still open for claimants to argue that a reasonable belief in a serious and imminent circumstance of danger outside of the workplace, such as fear of the COVID-19 pandemic, could engage the provisions at section 101D of the Employment Rights Act 1996. However, what is important going forward is that it must be shown that that belief prevents the claimant from returning to the workplace. That brings us to the end of this month's update. Thank you very much for tuning in. If you have any questions, please feel free to send me an email. My email address is on this slide. And do remember to look out for next month's webinar. Thank you very much.